satisfied if Judge Kavanaugh answers similarly. This is my 15th Supreme Court confirmation hearing since I joined the committee in 1981. 31 years ago, during my 4th Supreme Court confirmation hearing, liberal outside groups and their Senate allies engaged in an unprecedented smear campaign against Judge Robert Bork. As Mark Pulliam said in an op-ed over the weekend, quote, "The Borking of Robert Bork taught special interest groups that they could demonize judicial nominees based solely on their worldview. Worse, character assassinations proved an effective tactic, nearly sinking Justice Clarence Thomas's appointment 4 years later." But he also said, continuing to quote, "By confirming Judge Kavanaugh, the Senate can go some way toward atoning for shameful treatment of Justice Robert Bork 31 years ago," end of quote. Judge Kavanaugh is one of the most qualified nominees, if not the most qualified nominee that I've seen. A graduate of Yale Law School, clerking 3 federal judges, including a man he nominated to replace. He spent all but 3 years of his career in public service and has served as a judge for 12 years on the D.C. Circuit, the most influential federal circuit court. He has one of the most impressive records for a lower court judge in the Supreme Court. In at least a dozen separate cases, the Supreme Court adopted positions advanced by Judge Kavanaugh. The American Bar Association, whose assessment Democratic leaders have called the gold standard of judicial evaluations, rated Judge Kavanaugh unanimously well qualified. A review of Judge Kavanaugh's extensive record demonstrates a deep commitment to the rule of law. He has written eloquently that both judges and federal agencies are bound by the law Congress enacts. And he's criticized those who substitute their own judgment about what a statute should say for what the statute actually says. After President nominated Judge Kavanaugh, I said this would be the most thorough and transparent confirmation process in history. I say that statement even regarding all the discussion we've had this morning. It has proven to be, from Judge Kavanaugh's authoring 307 opinions, joined hundreds more, amounting to more than 10,000 pages. He submitted 17,000 pages of speeches, articles, and other materials to the committee, along with this 120-page written response to the questionnaire that the committee set out. These adds up to 27,000 pages of Judge Kavanaugh's record already available to the American people, and we received just shy of 500,000 pages of emails and other documents from Judge Kavanaugh's service as an executive branch lawyer, which is more than we received for the last 5 Supreme Court nominees. Every one of these more than 483 pages of executive branch records are available to any senator 24/7. I push for federal officials to significantly expedite public disclosure process under federal law so that all Americans have online access to more than 290,000 pages of these records right now on our committee website. In short, the American people have unprecedented access and more materials to review Judge Kavanaugh than ever have had for a Supreme Court nominee. And to support the review of Judge Kavanaugh's historic volume of material, I've worked to ensure that more senators have access to more material than ever. Since so much of the rest of my statement has been discussed this morning by what the Democrats have said, and I've answered a lot of it, I'm going to put the last 7 pages of my statement in the record, and I'm going to ask Senator Feinstein if she has more to say on her opening statement, and if she doesn't, I'll go to Senator Hatch, or do you have?
Thank you. I do, Mr. Chairman. I will probably truncate it even so. But I think it's really important that people, as well as the judge, the nominee, understand how strongly we feel and why we feel that way. Yeah, I want to talk a little bit about one of the big decisions that we have the belief that, although you told Senator Collins that you believed it was settled law, the question is really, do you believe that it's correct law? And that's Roe v. Wade. I was in the 50s and 60s active, but first as a student at Stanford. I saw what happened to young women who became pregnant. And then subsequently, I sat as a appointee of Governor Brown's on the term setting and paroling authority for women in California who had committed felonies. And so I sentenced women who had committed abortions to state prison and granted them paroles. And so came to see both sides, the terrible side and the human and vulnerable side. And when you look at the statistics during those days, those statistics that the Guttmacher Institute has put out are really horrendous. For you, the president that nominated you has said, I will nominate someone who is anti-choice and pro-gun. And we believe what he said. We cannot find the documents that absolve from that conclusion. So what women have won through Roe and a host of privacy cases, to be able to control their own reproductive system, to have basic privacy rights, really extraordinarily important to this side of the aisle. And I hope the other side of the aisle as well. Last year, you drafted a dissent in Garza v. Hargan, and that's a case where a young woman in Texas, I believe, was seeking an abortion. In that dissent, you argued that even though the young woman had complied with the Texas parental notification law and secured an approval from a judge, she should nonetheless be barred. In making your argument, you ignored and I believe mischaracterized a Supreme Court precedent. You reasoned that Jane Doe should not be unable to exercise her right to choose because she did not have family and friends to make her decision. The argument rewrites Supreme Court precedent, and if adopted, we believe would require courts to determine whether a young woman had a sufficient support network when making her decision, even in cases where she has gone to court. This reason, I believe, demonstrates that you are willing to disregard precedent. And if that's the case, because just saying something settled law, it really is it correct law? The impact of overturning Roe is much broader than a woman's right to choose. It's about protecting the most personal decisions we all make from government intrusion. Roe is one in a series of cases that upheld an individual's right to decide who to marry. It's not the government's right. Where to send your children to school, the government can't get involved. What kind of medical care you can receive at the end of life, as well as whether and when to have a family. And I deeply believe that all these cases serve as a bulwark of privacy rights that protect all Americans from over-involvement of the government in their lives. And to me, that's extraordinarily important. Next, I'd like to address the President's promise to appoint a nominee blessed by the NRA. In reviewing your judicial opinions and documents, it's pretty clear that your views go well beyond simply being pro-gun. and I'd like to straighten that out. It's my understanding that during a lecture at Notre Dame Law School, you said you would be the, quote, first to acknowledge that most other lower judges, court judges, have disagreed with your views on the Second Amendment. For example, in District of Columbia v. Heller, you wrote that unless guns were regulated, the Constitution was written, or traditionally throughout history, they cannot be regulated now. In your own words, gun laws are unconstitutional unless they are, quote, traditional or common in the United States. You concluded that banning assault weapons is unconstitutional because they have not historically been banned. And this logic means that even as weapons become more advanced and more dangerous, they cannot be regulated. Judge Easterbrook, as you know, a conservative judge from the Seventh Circuit, concluded that that reasoning was absurd. And he pointed out that a law's existence can't be the source of its own constitutional validity. In fact, I'm left with the fact that your reasoning is far outside the mainstream of legal thought, and that it surpasses the views of Justice Scalia, who was clearly a pro-gun justice. Even Scalia understood that weapons that are like M16 rifles or weapons that are most useful in military service can, in fact, be regulated. And there's no question that assault weapons, like the AR-15, were specifically designed to be like the M16. The United States makes up 4% of the worldwide population, but we own 42% of the world's guns. Since 2012, when 20 first graders and 6 school employees were killed at Sandy Hook Elementary, there have been 273 school